how do you defend somebody like Lucy Letby? She's been found guilty of murdering 7 babies on that neonatal unit, making her the UK's most prolific child serial killer in modern times. The 33-year-old has also been convicted of trying to kill 6 other infants. This was at the counters of Chester Hospital between June 2015, June 2016. She refused, and this is something I'm going to be talking to Joseph about, she actually refused to appear in the dock for the latest verdicts, and that's something that the government has talked about changing, that you have to actually face what you've done, if you like. This has been one of the longest running murder trials. It started off in October 2022. They didn't announce the guilty verdicts, etc., until the jury had been discharged. There's been quite an unprecedented level of people's names not being released, etc., of confidentiality. That's something else that I want to discuss with, as I said before, my next guest. I love talking to him, Joseph Kotrie Monson, lawyer and broadcaster. As much as I love talking to you, Joseph, this is a really difficult subject. So many things that I want to get through. For instance, not appearing in the dock is one thing. Let's do it in chronological order. And this is one of the longest running cases. I didn't realize that it had started in October last year. But how do you defend? Because I'm having a look at some of the things that the defense said. How do you, or what was the defense in this case? We've heard a lot about what the prosecution is, but we haven't heard a lot about what case the defense put forward.
Combination, really, in this case, of coincidence and disputing the science. And it's maybe surprising for some people to hear that, or to consider that disputing the science in a case like this as to cause of death might be a thing, because don't we have these really advanced pathologists, et cetera, et cetera? Mm-hmm. But the thing is, baby pediatrics, it's specialization upon specialization. Often experts disagree. That's a documented, this is a, you only need to look at the miscarriages of justice. There was that female solicitor, wasn't there, many years ago, accused of killing her own baby. There have been a number of scandals where doctors have given their opinion, been struck off, and then they've been given back their rights to practice by the High Court on appeal, because it never should have happened. Because these cases can be so loaded. Differences of opinion can make or break your career. The type of fear of witch hunt and being hounded out, that sadly seems to be a flavour of this awful case, is actually something that is a bit of a documented phenomenon in paediatric work, where it comes to legal expert witnesses. And also, of course, saying, well, it may seem unlikely, but where's the evidence? And actually, a great deal of the evidence, Trisha, in this case was circumstantial. And
one of those circumstances was that Lucy Letby was on duty every single death. She was the only one. I think the next one, she was about the only one. And
right.
The other, I was going to say, the other things wasn't it the insulin? Even Lucy Letby herself couldn't say why the levels of insulin in the baby were way, way higher than anyone had seen before, but she blamed somebody else.
Absolutely. And it's kind of that so many coincidences mounting up made up the case. It wasn't just circumstantial evidence being weak, but a huge number of coincidences. And that's the way the prosecution case was put by Nick Johnson Casey, as who both defends and prosecutes, friend of mine, somebody I've instructed in the past to act for my clients on behalf of the defense. The scandalous thing here, however, was that despite the fact that 7 pediatric consultant doctors said something's going wrong here and it's Lucy Letby, time and again, with time to avert many of these avoidable baby deaths, again and again and again, it was image and reputation over patient care. And this is what's so disturbing.
Well, this is what I was going to say. So, I mean, already we've heard from the families of these babies that they're not happy with that.
Yeah.
Does this lead the way to future? Well, here's the thing. If action is taken against those managers, let's say, and other medical negligence cases and what have you, there have been massive fines.
Or manslaughter, Trisha. Now, let's not presume what action might be taken, but are there grounds for an investigation, at least for corporate manslaughter, possibly even gross negligence manslaughter on the part of individuals? If you've got a duty of care and you fail grossly to a high level, an obscene level, as appears may have taken place here on the parts of individuals. I don't want to presuppose what a court may say. I will be seriously concerned if the police have already closed their book on the criminal investigation. That's the.
But here's the thing, Joseph. But if an NHS trust is fined, and there've been other situations, let's say they have to pay out hundreds of thousands, even millions. It's taxpayers' money, isn't it? Aren't the people in charge? They might go away with a big cross against their names. They already under siege NHS. And correct me if I'm wrong. If they have to pay lots of money, it comes out of doctors' and nurses' pockets anyway.
Well,
or does it get taken against a specific person who's held liable?
Well, there are different offences, and I don't want to presuppose too much. It could be the police are beavering away in the background on this already. But there are offences of gross negligence manslaughter that can be brought against individuals. Now, I don't want to point... I'm a defence lawyer, Trisha. Here I am talking about pointing fingers at individuals. Substantial questions remain in respect of the conduct of key members of the Countess of Chester Hospital. There is no doubt in my mind that those questions, the answers to those questions must be given to the families. This mediation version of a public inquiry, which doesn't even have statutory powers.
I was going to say nobody can be compelled, though, can they?
And you know what?
You can't be compelled to give evidence.
No, it's like the difference between mediation and a court case. They're offering some type of sop to the unanswered questions that protects the systems in place that allow doctors to be ignored at the behest of managers, presumably, maybe out of self-interest, maybe out of fear from politicians. That wider questions are raised as a result of all of this. And you're seeing now, just in the last few minutes, families have said, we are not happy with the idea of this closed shop version of a toothless inquiry. We want something proper, and they deserve it, in my view. I suspect in your view, and I suspect in the view of many of the people who've been shocked, repulsed and upset by hearing about this over the past few days, and in fear themselves. And the type of lack of confidence or damage to confidence in the NHS if this isn't addressed properly. And this is an institutional and governance problem. Absolutely. Absolutely.
Here's another thing that the level of anonymity. Talk us through why the judge, right at the beginning, and I know some newspapers applied to have that lifted, but created anonymity, not just for all the families. And I think we can understand why, because this was a number of years ago. You don't want a child going to school with everyone talking about, oh, that's why your brother or sister was killed, or your twin or your triplet, or what have you. So anonymity there, but also anonymity of, and it's brought up, one of our viewers sent in a message about this doctor that she apparently had a crush on, and gave evidence from behind the screen. Why so much anonymity across this case?
Well, we can't necessarily comment on the specifics of why that might have occurred, but there are a number of reasons. It could be fear, for example, and the fact that the person felt that they may be in danger as a result of the proximity that they had to the individual, even if that was blameless. For example, it could be on the basis of kind of public protection in that regard. We're not in a position to know what happens behind closed doors always in that regard. Generally speaking, justice should be done and seen to be done. I don't think anybody would have any problem or question regarding parents who somehow have to try to rebuild their lives.
That would be horrific. Here's the other thing. I was just reading about Lucy Letby refusing to appear in the dock for the latest verdict. Now, the government's actually sort of mentioned that there's been several cases recently where the person has been found guilty and won't stand up there and face the families or face the people that the relatives or what have you. This is just another example.
Yes, it's interesting actually. Dale Cregan, I think, was the first police officer, double killer, I think, possibly serial killer, who refused to attend his own sentencing hearing. That has become popularized among convicted people because I don't think before then it had occurred that there was a choice, or in reality, probably dock officers said, you're coming up or we're dragging you up. What the law says now is there is a penalty of up to 2 years if you don't attend. Of course, if you're getting a whole life term, as Lucy Letby knows that she must be getting, that's no motivation. There are Law Commission considerations at the moment, consultations with government with regard to a change in the law to compel attendance. I actually think that law existing to compel attendance will mean that people won't be dragged into court because they will know that they're under threat of being dragged into court and they will come in of their own accord.
So you think that something's needed? How much do you think it is?
I'm not. Whether it's needed or not, I think it's going to happen.
But how important do you think it is that somebody who's convicted of a crime actually stand up there and hear the judgment, hear what the judge has got to say, and that be seen to happen?
I think that families, especially in murder cases, want to be able to face the perpetrator. It's something that has become, as the criminal justice system has emphasized more the idea of redress and emotional closure for victims. More and more that has become a thing. I don't think that people ever get justice or true equalization after the wrongs they've been committed in such a situation. Justice is a blunt instrument to deal with the horrors of what people suffer and what at the hands of people who just occasionally in my job actually do qualify for that overused adjective evil. However, the idea of being able to face, if you want to, and families shouldn't be expected to. Sometimes it's too much of an ordeal, but for the people who want to be able to face their killer, whether they look at them or not, there's a point at which you think, well, do they have to be forced to look the person in the eye or not? There's only so far you can go. But I think that this law is inevitable. People will be told they'll be dragged into court, and as a result, they'll come in.
And just finally, it's the question I think that lots of people ask is, what do you as a defense lawyer do if you know someone is guilty? I'm guessing that you people would be assuming that you know they're guilty, or you've got a really strong feeling that they're guilty.
That's the first assumption. That's the first assumption. And I tell you what, I'm asked this question all the time, and I never regard it as inappropriate because it's a very natural human response to the work that we lawyers do. We do a couple of things. first of all, we perform a role in proceedings so that innocent people do not go to prison.
Right.
And for that to happen, we must defend all with our voice, in such, and our skill and all our energy, as if it was them using their voice and the skill and energy and experience that they don't have in these proceedings.
Yeah. But
So
what if
that
they're guilty, Joseph? What if you know they're guilty?
It's not for me to decide. Trisha, what you're suggesting.
But even if they tell you, even if they say,
Trisha, I've never asked you to do this, but let me finish. All right. You know, what you'd like me to say is, well, you know, if I'm guilty, can I somehow make the decision? Can I somehow decide not to represent them? Well, if I did that in my arrogance, I would be performing the role of the jury. I would be the judge and the jury. And not only that, in some cases, my first instinct is wrong. I've had cases where I see the papers and think, I don't know why this person is pleading not guilty, but they're adamant. And then the witnesses come into court, or the evidence comes into court, and it's not worth the paper it's written on. And I think, oh, wow, isn't it a good job that I didn't allow my prejudices about the case to make a decision in my hubris about how to defend this person or not to defend this person. But we also need to know this. And that's that the right people go to prison and they stay there. Because if I don't do a proper job and some other fancy lawyer, even better looking and more eloquent than me, Trisha, comes along and says, hang on a minute, I'm looking at this record of the trial. This inferior lawyer you had, he didn't do a proper job. Let's get you out on the Court of Appeal. Bang. Murderer is innocent. Murderer is out on appeal because I didn't do my job properly.
Yeah, that's not happened to you, but it has happened before. Joseph, thank you so much. It is a really difficult case, and I really respect what you've got to say. It's been fascinating hearing about your thoughts on what should happen as to the people who doctors flagged up that this was an issue and chose to, I call it covering backsides, however you want to interpret that.